learn to express the trust. The problem has been a lack of knowledge on the effects of trusts on our lives. We can become master of, not slave. Not to be construed as legal advice. Learn to express the trust. Technology views everything as a trust first, and not as a construed debtor, etc. Learn to express the trust and to follow the rules. We've been learning about creating, claiming, and moving titles, which is what this report is based on. We're utilizing AFV, UCC, IRS, GSA forms in expressing the trust. How they got us. Legal fiction, the assumption that something is true, even though it may be untrue, made especially in judicial reasoning, to alter how a legal rule operates. Specifically, a device by which a legal rule or institution, a trust, is diverted from its original purpose to accomplish indirectly some other objective. The constructive, cestui, KSS, straw man trust is an example of a legal fiction. In 1901, Henry S. Maine wrote, "I employ a legal fiction to signify any assumption which conceals, or affects to conceal, the fact that the rule of law has undergone alteration, its letter remaining unchanged, its operation being modified." It is not difficult to understand why fictions in all their forms are congenial to the infancy of society. They satisfy the desire for improvement which is not quite wanting, at the same time that they did not offend the superstitious disrelish for change which is always present. Privity of contracts, where privity means the relationship between two parties each having a legal recognized interest in the same subject matter, such as a court case or piece of property. The relationship between two parties allowing them to sue each other but preventing a third party from doing so. The requirement of privity has been relaxed under normal laws, modern laws and doctrines of implied warranties, trusts, and strict liability, which allows the third-party beneficiary or other foreseeable user, both trust terms, to sue the seller of a defective product. Could that non-performing product be a straw man, slave? To many students of the common law, privity of contract became a fetish, i.e. you're supposed to agree, or have knowledge of a contract to be liable. Student practitioners. As such, this change has operated to deprive many a claimant of a remedy in cases where, according to the mores, i.e. the dead, with no vision of the time the claim was just. Many came to believe that a court action could not be assigned. Even now it is asserted that a man cannot be made the debtor of another against his will. But the common law has been influenced by equity through trusts, where no common law disclosure be given, and a trust is wrapped in a colorable common law contract by the law merchant, i.e. the Uniform Commercial Code. A debtor could become bound by a UCC-3 through silence to pay a perfect stranger, even if he had no privity of knowledge. The common law courts made use of fictions, trusts, and pretended they were not doing that which they were doing. Bingo. This is what they do not want you to know. Hansen, Principles of Law and Contracts. Privity of a state. An estate is a trust, a mutual and successive relationship to the same right and property as between grantor and grantee, or landlord and tenant, also termed privity of title, aka warranty deed. A trust, you, as grantee, trustee filed by the previous owner, as grantor in a successive trust, expressing the trust with our signature and an AFV. In 1933 they took the gold from backing of Fed Reserve notes. A contract could no longer be completed. No consideration or value could be given. Common law vanished in the public, so all contracts become colorable. Lies, so trusts fill the void. Colorable contracts wrap a trust at the core, so everything is trusts, and the gifting of the res into the trust, forming the corpus of the trust. Your signature is the representation of the trust, and all your past, present, and future labor or assets, where your signature is the res value. Principle. Trusts. If two parties have the four elements of a trust, and employed one of the four methods of formation of the trust, then they have a trust, recognized in law, whether they know it or not, and the trustee can be held liable. Black's Law. Two kinds of trusts: express and implied trust. The right, enforceable solely in equity, in court, to the beneficial enjoyment of property to which another person holds legal title, a property interest held by one person, grantee or trustee, at the request of the grantor or settlor, for the benefit of a third party, the beneficiary. Expressed trust, a trust created with the settlor's express intent, expressing the trust voluntarily, usually declared in writing. An ordinary trust as opposed to a resulting trust or a constructive trust. Implied trust, which is involuntary, also called constructive trust, SS account, the form through which the conscience of equity, the court, finds expression against one who has obtained property by wrongdoing, when property has been acquired in such circumstances that the holder of the legal title, possession, 90%, may not in good conscience retain the beneficial interest title. The other tenth, equity, converts him into a trustee. They deem us to be holding title illegally, and they convert us into the trustee. It is sometimes said that when there are sufficient grounds for imposing a constructive trust, the court construes a trust. It implies a trust because we did not express a trust first. The expression constructive trust is absurd because constructive is derived from construe, not construct. The court construes the circumstances, it explains them, it does not construct them. Blacks. We don't express the trust, so they construe it to their benefit. Sestuike trust is an implied or constructive trust. Social Security #trust account. It is a beneficiary of the foreign situs trust because you didn't express the trust after age 18. The Sestuike is the remedy by which the court of equity finds justice for the one who has lost his property to one who does not legally have a right to the property. You're being construed as the one holding the property illegally. One is holding the property illegally when it has been acquired in such circumstances that the holder of a legal title may not in good conscience hold the beneficial or legal title, and equity converts him into a trustee. They construed the trust with you as a trustee under debtor-creditor law. You were supposed to pay, you didn't, so you were in breach of fiduciary duty. You can go to jail. You should express the trust with your intent under, say, equity or 1776 law form, which is pre-United States and pre-statutes and codes, so you could then pay with private credit or negotiable debt instruments, NDIs, and you would be safe in making private payments with private credit. They put you under public policy where you have to pay with FRNs. The substantive rights of the real man lie with equity, but the courts construe you as trustee with duty to pay them, as construed beneficiary, and friends. If you have a drinking glass in the private, a title is used to represent that drinking glass in the public. Express trust is usually expressed in writing. Implied trust. An implied trust is created when you don't express it. An equitable remedy imposed by the court, the form through which the conscience of the equity finds expression against one who has obtained property by wrongdoing, or when the holder of the legal title cannot in good conscience retain the beneficial interest. Equity converts him into a trustee. To understand trusts, study the workings of the IRS tax code, the motor vehicle code, municipal courts, property taxes, etc., that which we have been induced into signing. I recommend The Law of Trusts and Trustees, Bogart and Scott on Trusts, also wills and trusts in a nutshell. Key points in trust law. He who claims trust must prove trust. That burden of proof is a prima facie case, the proof of which is in the expression of the trust. 4 elements to a trust: 1. Parties, grantor, trustee, beneficiary; 2. A specific res property, the thing; 3. Intent; and 4. Purpose. Trustee holds the trust property and is subject to equitable duties for the benefit of the beneficiary. They make us trustee, beneficiary by the mere acceptance of benefits. Beneficiary disclaimer can waive. No one can be forced to be a fiduciary trustee, only voluntarily. Did you understand that you were creating a trust when you signed that document? Is this your signature? One is presumed to know the nature and content of what he signs, but no parties to the trust grantor, trustee, beneficiary need to know or understand that they are forming a trust. That does not negate the trust. Sec. 23. Restatement of the Law on Trusts, and also out of Gilbert's Law Summaries on Trusts, UCC is key, and quat, incomplete instrument, and quat means signed writing, whether or not issued by the signer, the contents of which show at the time of signing that it is incomplete, but that the signer intended it to be completed by the addition of words or numbers. They add pay to the order of and $1 million. They turn the offer you signed into a check. You can do the same, i.e. turn it into a check. Instead of trading our labor for FRNs, we have to learn to trade our credit for them. Trusts are formed by one transfer of the res to trustee, who is neither settlor nor beneficiary if the transferor expresses simultaneously with or prior to the creation of the trust. Transfer is another portal termed, under UCC sub 200, negotiation. A transfer is by one of four methods: endorsement, delivery in bearer form, assignment on AUCC 3, and also by operation of law. But a transfer is also a trust term. A transfer using one of these methods forms a trust. 2. A declaration in writing by the owner of the property that the owner holds the property as trustee for the owner and another person as the beneficiary. 3. Appointment, assignment, if the beneficiary makes a prima facie case the burden of contradicting it or showing a defense will shift to the trustee. Bogart discusses how there is a certain ill-defined threshold the beneficiary must prove, then the burden shifts to the trustee to prove that he met his responsibilities. He has no evidence he can prove unless he made the payment. Why would a beneficiary make a claim if he got paid? 4. By contract, the one who is able to prove the expression of the trust elements and has the burden of proof to do so. If not proven, there is no trust. In commerce, the trustee is presumed to be guilty. The one who is able to prove the expression of the trust. US v. SNEP. Warrant: the U.S. CIA sued SNEP because he had two non-disclosure agreements with the CIA to not publicize data. They sued him under trust law, not contract law. If there is an absence of a fiduciary, a court may appoint one. Equity will not allow a trust to fail for lack of a trustee. Acceptance of benefits is presumed. Under Bogart 169, all number references following are also from Bogart 191. Acceptance is presumed. There is nothing you need to do formally to become the beneficiary of these scams. The beneficiary may disclaim under 170 to 72 and 170 to 205 where conduct by beneficiary, including silence, amounts to a disclaimer, a refusal to accept the gift of the equitable property right. Since acceptance is normal, a claim of renunciation must be supported by clear evidence. Disclaimer is nunc pro tunc, now and for then, to the start of the agreement. 172 227 to 28. Conduct by the beneficiary which is inconsistent with his benefits may amount to an implied disclaimer, and statutes which require surrender of such trust will be in writing do not apply, since a surrender is based on giving up equitable interest. This is the unknown beneficiary problem, which can be your defense because the alleged trustee has no obligation to pay. How do you make a prima facie case? Simple. Come in with all the documents copied, and make an allegation. Beneficiary must show he is a beneficiary, managed by fiduciary, of a trust, with a trust res. In other words, express the trust. Where the beneficiary is unknown, the trustee has no obligation to pay. When they construe you to be trustee who hasn't paid, what would your defense be? The unknown beneficiary? Since the trust was not expressed, how would you know who the beneficiary was? or you could re-express the trust to your liking with yourself as beneficiary. Identify the party that needs to be paid. 161 at 133,134. Breach of fiduciary duty can put one in jail. Misapplication of fiduciary property or prop of financial institutions. Embezzlement. Misappropriation. 18 U.S.C. 371. Defraud includes embezzlement. 18 U.S.C. Section 371. Conspiracy to defraud the United States. The General Conspiracy Statute, 18 U.S.C. Section 371, creates an offense. And quod if two or more persons conspire either to commit any offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, the trustee may deviate from the terms of the trust if all beneficiaries agree to that. Scots on abridgment. 216. As an example, let's say there are several beneficiaries and the trustee wanted to make a donation to an organization which is not listed as a beneficiary in the trust. If all but one of the beneficiaries support it, the trustee cannot. It must be unanimous. Polk, who was the beneficiary, v. Farmers Trust and Loan 157 U.S. 429, 1895. To reconvey the mortgage, you must terminate the trust. When you signed the application for the loan, the bank monetized your signature, got paid, deposited into an account. Then you signed the promissory note at closing, which they deposited onto the right asset side of the ledger, and deposited your security agreement on the left debit side. Do debt validation, then get them in dishonor, which we use for revoke of power of attorney. Re-express the trust with appointment of trustee equals bank. Since they're the beneficiary, the trust terminates because they can't be both. Now the trustee must disperse funds to the beneficiary. As grantor, you instruct the trustee therein. Breach debtor-creditor laws where you're paying for 30 years. Establish holder in due course. Status